Bienenfeld Law with Saul Bienenfeld.
Today I want to talk about something that every criminal defense lawyer experiences, but almost nobody talks about. And that is defendants that go through various states of grief. Now, they don't go through it metaphorically, they go through it literally. There's denial, anger, bargaining, depression, and acceptance. Most of us learned those stages from Elizabeth Kubler-Ross, originally she described people's process, terminal illness and death that way. But here's the thing. For many defendants, criminal charges feel like the death of the life they thought they had. Their reputation, their freedom, their family relationships, their future, all of it suddenly feels uncertain. And that emotional reality fundamentally shapes how clients behave, how they make decisions, how they interact with their lawyers. So today, I want to talk about the 5 stages of grief in criminal defense and how understanding them can make a person a better lawyer, and frankly, make the lawyer's life a lot easier. Because once you understand what's happening psychologically, you stop thinking, why is this client being impossible? And you start realizing they're grieving. They're actually grieving. When someone is charged with a crime, it's not just a legal problem. It's a personal crisis. Most defendants are subtly confronting things they never imagined. Possible incarceration, financial ruin, losing a job, losing custody of their children, losing a spouse, and becoming permanently labeled a criminal. That's not just stressful, that's existential. Psychologists define grief as the emotional process of reacting to major loss. And that loss doesn't have to be a death. It can be loss of identity, the loss of a reputation, the loss of the future someone imagined for themselves. And in criminal cases, there's another problem. The grief is disenfranchised, meaning society doesn't recognize it as legitimate. If someone loses a loved one, people bring food. If someone gets arrested, people disappear. Friends vanish, family distances themselves. And suddenly the one person standing between the client and the system is me, the criminal defense attorney. Well, the first stage is denial. And every defense lawyer has seen this. The client walks in and says, this is all a mistake. They have nothing on me. They can't prove anything. Sometimes the evidence is overwhelming. There's video, there's DNA, there's confessions, but the client still says, I didn't do it. Or they can't prove it was me. Now, here's the important thing. Most of the time, this is not lying. It's psychological protection. Denial is the brain's way of preventing emotional overload. Because if the client fully processes what might happen, prison, shame, public humiliation, it feels unbearable. So the brain delays reality, and denial shows up in predictable ways, minimizing the seriousness, blaming someone else, selective memory, and misinterpreting the evidence, of course. You could show them a video and they say, that could be anybody. You show them phone records and they say, that doesn't prove anything. Now, from the lawyer's perspective, it feels and seems irrational, but psychologically, it's protective. So what should a lawyer do? First, don't confront denial aggressively. If you try to smash denial immediately, you often make it worse. Instead, build rapport with the client. Introduce reality slowly. Ask questions like, what do you make of this evidence? What do you think a jury might say about this? How do you think the judge is going to see this video? The goal isn't to defeat the client. The goal is to guide the client toward reality gradually. Eventually, denial cracks, and the next stage comes in, and that's anger. But here's the fun part. The anger is usually directed at me. Suddenly the client says, you're not fighting hard enough. My last lawyer said this case would be dismissed. What are you doing? Why aren't you filing more motions? Or they blame everyone else. They blame the police, they blame the victim, they blame the judge, they blame the whole system. The whole system is rigged. Here's the key insight. Anger is usually fear wearing armor. Underneath that anger are emotions like shame, terror, helplessness. Anger creates the illusion of control. And many defendants, especially those who have experienced trauma or systemic injustices, already have deep mistrust of institutions. So the criminal justice system feels like a confirmation of that mistrust. So what should lawyers like myself do here? 3 things. First, never take it personally. Second, set boundaries. Say things like, I understand you're frustrated, but yelling at me, yelling at my staff, it's not going to help your case. And third, channel that anger productively. Turn that energy towards preparation. Start writing out witness lists. Do a discovery review. Come up with case strategy. Anger actually means that the client is finally engaging with reality. Even if they're yelling at me doing so, they're engaging with reality. Stage 3. We reach the most fascinating stage at this point, and that's called bargaining. This is where my clients try to negotiate with reality, and it often sounds like this. I'll plead to a violation. I'll plead to disorderly conduct. I'll plead if they guarantee me no jail time, even when the charges are extremely serious felonies, or they develop magical thinking. If I just explain to the judge what happened, or if the prosecutor hears my side of the story, if I show them that I'm a good person, this is where the brain is trying to restore agency. When everything feels out of control, bargaining creates that sense that the situation can still be negotiated away. And sometimes religion enters into it here, and clients say things like, I've been praying and God will fix this. And it's important not to mock that, okay? Spiritual frameworks can be psychologically stabilizing. But as lawyers, we have to gently bring that conversation back to legal reality. This stage is actually useful because bargaining means the client has started to accept that something bad might happen. They're just trying to limit the damage. So this becomes the moment when lawyers can introduce realistic plea discussions. You can say things like, well, in similar cases, here's what usually happens, or if we went to trial, here's the risk. So bargaining is the bridge between denial and acceptance. Then comes the hardest stage, depression. This is when the client finally confronts the losses. They start thinking about prison, losing their job, their kids, their spouse, their reputation, their future, and they shut down. You see behaviors like missing meetings, not returning phone calls, saying, just do whatever you want. Some clients become fatalistic. My life is over anyway. What difference does it make? And in criminal defense, depression can be dangerous because it can lead to missed court dates, probation violations, substance abuse, suicidal ideation. But psychologically, depression also represents progress because the client is finally acknowledging reality. They're mourning the life that they thought they had. And for lawyers, the key here is balance, empathy, without the case stall. You can say, I understand this is incredibly difficult, but also, we still need to prepare for the suppression hearing next month, so let's get to work. Structure helps depressed clients. Concrete tasks restore a sense of control. Finally, if things go well, clients reach the final stage, or the 5th stage rather, and that's acceptance. And acceptance does not mean happiness. It doesn't mean agreement. It means clarity. The client begins to say things like, I understand the risks of trial, or I want to minimize jail time. What should I do next? Now they can actually participate in their defense. They can weigh options rationally. They can decide whether to take a plea, go to trial, negotiate further. And here's the important thing. Acceptance isn't permanent. Even clients who reach acceptance can regress. A new piece of evidence appears, a plea offer changes, a sentencing report comes in. Suddenly the client goes back to anger or depression. That's pretty normal. Grief is nonlinear. Clients move back and forth between the stages depending on what's happening in the case. Understanding this framework changes how I could practice law. Instead of thinking this client is impossible, I realize this client is grieving. And once I could recognize the stage, I could adjust my approach. With denial, I could introduce reality slowly. With anger, I don't take it personally. With bargaining, I could discuss realistic outcomes. And with depression, I can maintain structure and support. And finally, with acceptance, I can have a real strategic conversation with my client. It also helps that I protect myself emotionally, because criminal defense involves constant exposure to human crisis. So understanding these patterns helped me respond with empathy, without burnout. At the end of the day, criminal defense isn't just about motions and evidence. It's about guiding human beings through one of the most terrifying moments of their lives. Clients rarely understand their own emotional journey, but if I recognize it, I can guide them more effectively. And sometimes the job of a defense lawyer isn't just fighting the government. It's helping a client move from denial to acceptance. Because that's the moment when real decisions can finally be made. And that's when I can actually do my best work as their lawyer.